I finally started wising up and bringing a coat or a pullover into this class. It's so dang cold. You would think we'd start getting some heat here soon. Did you bring your blanket? That's what you said you were going to. That was smart. All right, so today we're going to finish up contract law. And then remember, this is a 2-week unit. So there will be a quiz over last week and this week that I will post soon. And then it'll be due Monday night. You will have another discussion question this week. And I know we talked about this a million times, but it gets confusing. Your discussion questions are not due till the end of the semester. That's when I'm going to grade them, but please don't wait till the end. But if you have not done a couple of those, you have time to go back and do them. No assignments this week, just that quiz. We also are not going to have class on Thursday for Halloween. I can finish up contracts today and figured I would give y'all a day off. So no class Thursday. What about Tuesday? Next Tuesday for election day? We are going to have class that day. But I'll excuse you if you're going to vote. You're not voting? You're going to vote that day too? Do y'all want to not have class on Tuesday then? No? You got to know. That's a very good question. You got to know what your deal is. No, we would just meet next Thursday. We'll just start over next Thursday. Is that good with y'all? Okay. All right. But if you told me you've early voted, then I know that you don't have an excuse. No, I'm just kidding. All right, we will not have class Halloween or election day. You can thank Miss Marshall for that. I don't like teaching when there's nobody here. So, I mean, I just assume everybody be here or none of us be here, one or the other. So last week, our discussion was on the elements of a contract, which are agreement, consideration, capacity, and legality. And we covered agreement and consideration on last Tuesday, and then we discussed some of that on Thursday with our cases. So that leaves us today with capacity and legality. So let's knock those out. Generally speaking, a person is going to be presumed to have capacity to enter into a contract. So if the defense is that I didn't have capacity, that would be up to me to prove. Okay, we all can be, and that preserves our ability to conduct business. We don't have to go around verifying whether or not somebody has capacity before we enter into a contract with them. It's okay to presume that everyone does. There are some classes of people that do not have the capacity to enter into a contract. One of those is minors. The rules for minors are kind of weird. So in most states, the age of majority for contractual purposes is 18. A minor can still enter into a contract before the age of 18. They just have some special rules about whether or not it's enforceable against them. Okay? So a minor can, like I said, enter into a contract. A minor can also disaffirm a contract, meaning go to the other party in the contract and say, I no longer wish to be bound by this contract. They can get out of it while they're still a minor. An adult who enters into a contract with a minor can't get out of it. So it's a one-way street when it comes to minors. The minor can wiggle out of it on the grounds of I'm not 18. But the adult who enters into the contract with the minor cannot get out of it. Now, what happens when a minor turns 18? So the rules are loosely that when a minor turns 18, they could elect to disaffirm the contract, get out of it, cancel it, make it void, or they could ratify it, meaning they're going to say, now that I'm 18, I do intend to be bound by this contract. There's not some website or app that you sign up for where you disaffirm or ratify contracts by pushing a button on your phone. That's measured by conduct. Words, writings. Certainly a minor could, let's use an example of a minor buying a car. So my 16-year-old daughter buys a car and she turns 18. She's financed it, so she's been making payments all this time. And she continues to make payments on the car for the next year till she's 19. Then she shows up at the dealership and says, you know, when we entered into that contract, I was a minor, so I would like to disaffirm the contract. Probably too late for her then. Probably too late. If she shows up on her 18th birthday and tells the dealership, here's your car back. I was a minor. I'm canceling this contract. That's fine. If she does it the next day, probably still fine. Gets into a little bit of gray areas if she, let's say, makes, you know, a couple of payments or doesn't make a payment the first month, makes a payment the second month. So that would be up to the judge or the jury to decide whether or not the minor's conduct, a reasonable person would assume that the minor intended to be bound by the contract or to cancel the contract. Some states, well, I hate to even get into that. Some states will make a minor pay the reasonable value of goods or services if they've consumed them. Like if a minor made a contract for food and they ate the food, they still might have to pay it back. But I don't want y'all to get hung up on that. What I want you to know about that is that a minor can disaffirm a contract at any time before 18 and in a reasonable amount of time after turning 18. The adult cannot get out of the contract. So let's say that my daughter went and bought a car. The dealership sold her the car. They entered into a contract for the sale. When she's 17, the dealership cannot come back and say, hey, you got to bring that car back. We're canceling the contract because you're a minor. The adult cannot get out of it. Parents are generally not liable for their minor children's contracts unless they're a co-party. If they're a party to the contract themselves, in other words, they are also the promisor or promisee, then they might not be able to get out of it. But generally speaking, if my daughter bought a car at age 16 and wrecked it and drove it up to the dealership and dropped it off and said, ha, sucker, I'm only 16, here's your car back, they cannot come after me on that. Intoxicated persons is another category of people who lack capacity to enter into a contract. So we saw some of this last week in our case of Lucy versus Zemer, right? Zemer's defense was, I was high as a Georgia pine. And it was up to the judge, to decide whether or not, based on the objective facts and evidence, whether or not a reasonable person could conclude that Zemer knew what he was doing, could appreciate his actions. We talked at length, I think, last week about how that's going to vary depending on the substance, the person, their tolerance, the setting, the circumstances. If I go to my lawyer's office to complete the purchase of a real estate contract and it's 9 a.m, very unlikely. It's not reasonable for me to think that the person across from me is intoxicated to the point that they don't have capacity to enter into a contract. If I enter into a contract with them at a club downtown at 1 a.m. on Saturday morning, that's a different setting and a different story. Mentally incompetent persons is another category of people that lack capacity. So make sure my microphone doesn't die. Let me explain to y'all how mental incompetence works in Georgia. This is going to be different state by state. This is not on your test. I just think it'll help you understand how this would apply in contracts. So we say all the time, so-and-so's crazy. So-and-so is out of their mind. They don't know what they're doing. Okay. But unless a person has been adjudicated or judged or declared mentally incompetent by a court, then legally they have capacity to enter into a contract, to make decisions for themselves, to consent or reject medical care, those types of things. The way it works in Georgia is if we suspect that somebody does not have capacity, and I see this come up in two main ways. I see this come up a lot of times when developmentally disabled individuals or minors who are developmentally disabled turn 18, and then their parents no longer have legal authority over them. So they'll say, we need to go to court so that we can be declared their guardian. You've heard of that. So that we can make legal decisions for them. The other place that I see it commonly is in older people who are losing their faculties and who are, who are starting to suffer from dementia or Alzheimer's or those sort of things. They can't make decisions anymore for themselves. And their family members typically will go to court and ask the court to declare a guardianship for decision-making purposes over that person. So those are the two places I see it most common. It could be any age adult could have a guardian, but it's by application to the probate court in Georgia. And the standard is that you have to prove that the person cannot make significant, responsible decisions with respect to their own health and safety and well-being. Again, I'm not testing you on the probate court guardianship standard. I just want you to see it's a pretty high standard. What do you think what kind of evidence do you think you would need in a probate court guardianship case to show that somebody lacks the ability to make significant, responsible decisions for themselves? What would be the best evidence of that? Say that again, Mason. Yeah, some evidence of conduct, but if I wanted an expert witness, I'd have the doctor come in and say, in my professional opinion, this person is suffering from dementia or Alzheimer's or autism, or they have some sort of developmental delay that prevents them from making responsible decisions. So the probate courts in Georgia, whenever there's an application for guardianship, they will require that the person be evaluated by a doctor. So you gotta do it by an expert doctor's testimony, and that protects us from being taken advantage of. You think about bad situations where children might want to go and take over their parents' finances for various bad reasons. There are plenty of good reasons, obviously, we would want to manage finances for somebody who's incapacitated. The scamming, y'all, is off the charts of old people. And I think about there's scams that I get in my email box all the time that I'm like, that I have to catch myself and be like, that's a scam. So I can't even imagine how difficult that would be. But we've had just really tragic cases that I've been involved in over the years where people have just sent thousands of dollars to criminals, and the criminals are really, really ruthless. So I sort of got off on a tangent on that, but I wanted y'all to sort of understand how that is. Have you ever seen the movie I Care a Lot? Nobody seen that movie? You seen that movie? That's it was about this lady who she would go to court and ask to become the guardian of people, but she was in cahoots with this doctor at an old folks home, and the old folks home doctor was pointing out easy targets, and then they would go and get guardianships over people. It's not realistic because they were doing it without the people knowing, which that's not how it works in real life. You have to notify family and you have to notify the person that had to be there and all that. But anyway, she was basically stealing from old folks. But she got it in the end, didn't she? You remember how she got it in the end? Yeah, that woman's son. Yeah, he shot her up, but he got her good. So that's how that went down. But so all that point being that in order to not have capacity to enter into a contract in Georgia anyway, you would need to be on mental grounds. You would need to be it would need to be somebody that's been to court and been declared in need of a guardian. They can't make their own decisions. They can't enter into contracts. Now, there are plenty of people who have had guardianships placed over them that if you talk to them at certain times, you wouldn't know. You would think they have capacity. There are people who can hold it together pretty well. There are people, even if you think about if you've ever known family members or friends that have had dementia and that sort of thing, they have good days and bad days. There's some days they could tell you exactly what a contract means and what they want to do, and then the next minute not remember it at all. So it is tricky for the other party to the contract when that happens. So those would be the main categories that I want you to know about for capacity. Minors and the special rules that apply to minors, intoxicated persons, and mentally incompetent persons. Yes, sir.
I was talking to somebody once that was either mentally incompetent or they told me they couldn't go to jail. They couldn't be convicted of a crime.
So the question is, somebody said they couldn't go to jail or couldn't be convicted of a crime. That is a defense to a crime, but it's not like a immunity. Like you can just walk around and say like, "Hey, I'm incompetent. You can't arrest me." They still get arrested. They still have to be evaluated by an expert and declared mentally incompetent to stand trial. And a lot of those folks end up being institutionalized, and they're not in jail, but they're staying at a psychiatric facility instead of jail. But that's most of the time how that works. But that is a defense to a crime. It's not an easy one, though. It's not one you can just elect and say on your own. It would have to be verified by some independent people. And unfortunately, I'm just going to like to go on tangents this morning, but there are a lot of folks who are accused or have been arrested and charged with crimes who have the defense of mentally incompetent to stand trial, and it takes so long for them to be evaluated and declared one way or the other that they're just sitting in either jail or a psychiatric facility for a lot longer than they should. Not like you just say, hey, I'm raise my hand, mentally incompetent. Next week we'll get you evaluated, and the next week we'll make a decision. I'm talking like months, sometimes a couple of years. It's really sad. It is very, and also while I'm on it, I'm just going to go off this morning. Our jails, at least in Georgia, and I think it's probably true of our country as a whole, but they have become one of the main providers of mental health services in our communities. The jails. But there are a lot of, there are a lot of folks who have mental health diagnoses that are getting arrested based on conduct or things they're doing that are really a manifestation of their mental health problems. They're still wrong actions. I'm not excusing them, but I'm saying that's really more a product of them not getting the treatment that they need in the community. So they're ending up in jail, and the jail is ending up bearing the responsibility of providing mental health services, and the jails don't do a good job of that. That's the least effective place, in my experience, to get your mental health services. Now, there are some folks who go to jail and stop taking drugs and start taking their shots or their pills, and they get stable. So it's not all bad, but generally speaking, the jail is not. That's just not the place you want to be getting your mental health services from. So, moving on to the next topic in contract law, which is legality. Let's talk about this last element of legality. A contract has to have a legal purpose, a legal subject matter in order to be valid. So the example I used for you last week was if I made a contract with Big Worm to deal his cocaine and he didn't pay me, and I tried to sue him for not paying me for dealing his cocaine, I would not have a valid enforceable contract because the subject matter of our contract was illegal. Y'all know who Big Worm is, right? Yeah, from Friday. Good, thank you. Big Perm. Big Worm. So some other examples. Obviously contracts to commit a crime, like hiring somebody to kill somebody, that's not a valid contract. But also if a contract is against the law in other ways. We have laws against interest rates, or how high an interest rate could be. Those are called usury laws. About how high an interest rate that you can legally charge another person in a contract. If the contract involves a rate that's higher than the law allows, then that contract would lack the element of legality. Same thing for your outline says gambling. So that's tricky now, right? Because in the last 10 years, a lot of states have legalized gambling. So if you're in a state where gambling is legal, it might be that gambling debt that you owe is an enforceable contract. Now, they're highly regulated. Most of the legal gambling is like casinos and that sort of thing, sports books. Not like me calling up, my buddy from college who's been taking bets for the last 30 years, and I'm betting on the NFL, and I end up owing him a few $1,000s, and he's going to break my legs if I don't pay. That's probably still not enforceable. See,
You have the slot machines and stuff.
Can you have them?
Like in gas stations.
Well, it is legal to have them in gas stations. I don't know the exact requirements, but I do know that a lot of the places that have them, there's something illegal about it. Either it's the payout they're given or the amount or something. I know there's some people that get in trouble for it. I don't know exactly what the rules are, but I know it's not illegal just to have one.
My brother told me they have to pay out.
Yeah, you can't. You're not supposed to pay out cash, right? I think something like that. But I mean, yeah, you're not going to do much business if you're giving out bananas for winning the slots at the Circle K. That ain't why people are going. So I think that they are in and of themselves legal, but I think a lot of stores operate them in illegal ways. Statutes that govern licensing, like the state of Georgia has a statute that says you can't practice law without a license. So if somebody who did not pass the bar and get licensed by the state bar of Georgia is practicing law, they're in violation of that law, and any contracts they make in the purpose of that business would be unenforceable. So, like if I'm not a lawyer, but I pretend to be, and Mr. Woods comes to me and hires me to be his lawyer, and we enter into a contract for him to pay me. He doesn't pay me. I sue him for it. That's not going to be a valid contract. It's going to lack the element of legality because I'm illegally holding myself out to be a lawyer. Okay, story time. This is one of my favorites. I had a case a couple of years ago. It's been about 5 years now, where this lady had a baby that she wanted to place for adoption. So she was working with an adoption agency out of Atlanta, and they found adoptive parents, and the baby was born. The baby went home from the hospital with the adopted parents, but the birth mom was still messing around with the birth father. But she had told the agency and the adopted parents and everybody that she didn't know who the father was. So they were proceeding all this time under the idea that there was not going to be any father involved. Well, she and the father had like an on and off relationship, and she went back to him and told him what she had done. So he went to court to try to establish some rights to the baby, and I ended up getting hired by the adoption agency to fight this guy's case. And we ended up winning the case. The guy he was not able to establish his rights to the baby. But he was, I was about to say crazy. He had not been declared incompetent by any courts in the state of Georgia. This man was crazy. He had been to jail for practicing medicine without a license. He put out a sign and said, "I'm a doctor." And he was seeing patients. And he got one of these ID numbers or something, and he got somehow, the little the boxes where they dispose of the waste, the medical waste, where they come up. I mean, like he had a coat with his name on it and stuff, and he was practicing medicine. Now the people going to him should have known, but I mean, I don't know how he got any patients. But he spent a year in jail for practicing medicine without a license. I had never heard of that before. That was one of the saner things he actually did. He also had he had kids by like maybe 5 or 6 women, and he also went to jail for threatening to kill one of them. And we had some of the letters he wrote from prison that were like, he was very specific about how he was going to murder her. But the end of the letter was like, love you forever, babe. Can't wait to see you. You're my boo. I mean, it was not a hard case. It was one of the easier cases I've had. But anyway, another way that a contract might lack the element of legality is contracts that are in restraint of trade. So if an industry or a company is colluding in a way that there are interfering with the free market, fixing prices, illegally getting market share so they can drive up prices, price gouging. Those are all illegal activities. So they would lack the element of legality. In the news lately has been a finding by an administrative agency. Remember, we talked at the very beginning of the semester how administrative agencies can make rules that are the equivalent of law. And an administrative agency, it escapes me right now which one, came out with a rule that said that non-compete agreements were no longer valid. So y'all heard of a non-compete agreement, a covenant not to compete? These are found in employment contracts mostly, and they would be where, let's say that I own a software development company, and Phil is one of my software development engineers, and we're in a employment contract. I agree to hire him for 3 years. He's going to agree to develop my software, but as part of that contract, it says that he can't leave and work for a competitor for a period of time after he works for me. They vary, a month, a year, 3 years. So these are pretty common in industries or areas where you would want to protect your proprietary tools, knowledge, property. You know, I don't want to pay Phil to develop all this software only for him to take it to a competitor the next day. So covenants not to compete are to protect the employer. They are judged differently state by state because each state has their own laws on covenants not to compete. But the main point I want you to know about them is that they're judged on a few different factors, namely duration, geographic scope, and we're going to talk about these. Duration, geographic scope, and subject matter. So duration. Phil's covenant not to compete in his contract with me says that he can't work for another software developer for 20 years after he leaves me. That's probably going to be found to be unreasonable. 20 years is a little too long to protect me. But the covenants not to compete are intended to protect the employer. So we only want to protect the employer for as long as it's reasonable to do that. How long might be reasonable? I don't know. I mean, it's going to depend, but a year seems pretty reasonable. 6 months certainly seems reasonable. The second one, in addition to duration, is geographic scope. So maybe, let's forget software for a second. Let's say that I sell paper, and my business is limited to the Southeast. No, all my customers are in Georgia and Alabama. Phil's a salesman for me. And we have in his contract a covenant not to compete that says that he can't work for any competitor or anybody that sells paper for 6 months anywhere in the world. The 6 months is probably fine, but the anywhere in the world is a little overbroad. Because if he moves to Hawaii and wants to work for a paper company there, there's no danger to me. They don't have customers here. So it's going to be a sort of a sliding scale of all the different factors in terms of reasonableness. Also, when it comes to purpose, let's say that Phil's covenant not to compete says that he can't work for anybody in any industry anywhere for 6 months after he works for me. 6 months is probably not that unreasonable. Anywhere in the world might be a little much. any industry is definitely too much, right? That's farther than it needs to be to protect my interests. Who cares if he goes to work for a software development company? I sell paper. There's no danger to me in him going to do that. So the lesson is on both ends. If you are an employee and your employer wants you to enter into a contract that contains a non-compete agreement, you need to think long and hard about whether or not that's fair to you and whether or not that would be upheld in court if you challenged it. If you're an employer, you absolutely want to protect your proprietary information, knowledge, your competitive edge. But you don't want to write a non-compete in a way that might get invalidated by a court. Now, as a practical matter, if Phil works for me selling paper and he has a non-compete that says he can't work for a competitor for 6 months after he leaves me in Georgia or Alabama, and he leaves me and goes to work for my brother's paper company, who's my main competitor, I could go to court and maybe get an injunction to stop him from working. But is all this going to get sorted out anytime soon? Litigation is not quick. It would be a long time before the court actually made a ruling. I mean, they could temporarily stop him from doing it. But all this isn't going to get sorted out and resolved on a final basis for a while. So just because as an employer you've got the ability to enforce something in court doesn't mean it's necessarily going to be quick. And as an employee, you think it's something you can get out of in court, you can have that agreement invalidated. That isn't going to happen soon either. So those are practical considerations for that. The rule that the administrative agency made that invalidated all covenants not to compete got set aside by a court, and that's being sorted out right now. I need to get an update for y'all on that because I'm curious myself as to where that stands. But that is something to pay attention to. That we had a government agency that actually went so far as to try to make any covenant not to compete illegal. As an employee, that would be great. It's like having total free agency. If I'm an employer, I don't like that at all. I want to be able to protect my business from people stealing my stuff, secrets, knowledge. Also told you last week that if a person makes a bad deal, that the court's generally not going to get involved in judging whether or not the consideration was enough. That is true. There are some contracts, though, that are so unreasonable, so unfair. The word is unconscionable. They're so unconscionable that a court might step in and say, we're just not going to enforce that. It happens not when a person has done something voluntarily and knowingly and intentionally, willingly. It happens more often when there's like an imbalance of power or knowledge. Basically, somebody got taken advantage of. And the person who's on the wrong side of it took advantage of a person in a way that a court is just saying, we're just not going to enforce that. I remember one time my grandmother got sold something by a salesman, like a door-to-door salesman. It was like, maybe it was one of those, I think it had to do with like a shower or a walk-in tub or something. And I called them up and I was like, I dare you to, like, we're not entering it. I mean, we're not going to honor this contract. And then they gave me all the stuff about, it's valid. And I was like, all right, sue me, sue her. And we'll see if that stands up. And they didn't. But That might be an example of something that might be unconscionable. If the terms of it are just so unfair. Unconscionable. There are situations when, well, let me be a little more clear. That kind of stops the element of legality. I want to go into some defenses to a contract, something that parties might use to invalidate a contract on grounds other than one of the four elements are missing. A mistake. Mistake is generally not going to get anybody out of a contract unless it's obvious and the other party knew or should have known it was a mistake. Like, I think we talked last week, the example where I was going to sell my collector Porsche that's worth $4 million and I left off a bunch of zeros and typos and it was 400, and the other party knew that there's no way that the car could be worth $400. That might be a defense to enforcement of a contract. But it's not always. It's not always. It would depend. A mistake of value. So here's an example where a mistake wouldn't get you out of it. If I bought, if I found some antique vase in my attic that belonged to my great-great-grandmother, and I sold it down at the flea market for $10, then I later on discovered that it was worth $1 million. That's my mistake. That's not going to get me out of the contract. It's a unilateral mistake of value. If there's fraud involved, that is absolutely a defense to a contract. So you might have all the elements of a valid contract, but if one side was defrauding the other, withholding relevant material information or giving wrong information on purpose, that would be a defense to a contract. Undue influence could be a defense. That might be a situation where a person is doing something because they feel like they're pressured to or they have to. There's a power imbalance. They weren't really exercising free will. That might be a defense to a contract. Similar to that would be duress. Somebody holding a gun to my head, making me enter into a contract. Somebody telling an old person they're going to quit feeding them, or they're not going to be able to see their loved ones or something like that. That'd be duress. Those could all be defenses to a contract. So all of the things that we've talked about today would be reasons why a contract would not be enforceable. That's not true. Not all of them. If a contract lacks one of the four elements of agreement, consideration, capacity, or legality, you don't have a contract at all. You could have a contract but still not have it be enforceable because of one of these defenses like fraud or duress or undue influence or those type things. Same effect. At the end of the day, you're left with a contract that nobody can enforce anything. We just got there different ways. The last thing I want to talk about is the writing requirement. So I told you last Tuesday that not all contracts have to be in writing to be enforceable. And that is true. Not all contracts have to be in writing to be enforceable, but some of them do. There are some types of contracts that if they're not in writing, they're not enforceable. You don't have a contract. The writing requirement is extremely, the name of it is misleading and confusing. It's called the Statute of Frauds. Every state has a statute of frauds, and the statute of frauds is a law that says what kind of contracts do have to be in writing. I'm not really worried about you knowing the legal term of that. I'm more worried about you knowing what kind of contracts do have to be in writing. Okay? Contracts for the sale of an interest in land have to be in writing. So if in our Lucy versus Zemer case last week, if that contract had not been written down on the check, if it had all been oral, we never would have even gotten to court. Because it was a contract for the sale of land, it had to be in writing. And it was. That wasn't the issue in that case. Contracts that cannot, this is tricky, contracts that cannot, by their terms, be performed within 1 year have to be in writing. Here's how this gets tricky. CSU, I enter into a contract with CSU to teach for the next 3 semesters. By its terms, I cannot do that in a year or less. 3 semesters is longer than a year. But if CSU and I enter into a contract verbally for me to teach for the rest of my life, that actually could be performed in less than a year. It could be. So it's not whether it will be, it's whether it could be. Because I could die before the year ends. So if a contract by its terms cannot be performed in a year or less, has to be in writing. The lesson, again, like I told y'all last week, put everything in writing. Don't risk it. I hope you can see, one of the things I wanted y'all to do in your discussion question last week is I want to know the lessons you've learned from contracts. I hope one of them is to put everything in writing. I hope that's the first lesson that you've learned. So contracts for the sale of the land have to be in writing. Contracts that cannot be performed in less than a year have to be in writing. Anytime you are promising, anytime there's collateral being pledged for a loan, that has to be in writing. I've got a contract with Ford Motor Company to finance my car. And as part of that contract, I'm giving the collateral I'm putting up is my car. They can have my car if I don't make the payments. That's the kind that has to be in writing. Promises made in consideration of marriage. I don't even know why I have this in there still. I mean, that is the law, but I have never heard of any case where somebody entered into a contract made in consideration of marriage. And then contracts for the sale of goods for $500 or more has to be in writing. So you can see that most contracts do have to be in writing, just not all of them. Again, lesson being, put it in writing. That concludes our study of contracts. Does anybody have any questions? All right, so your quiz on that's due Monday will be over last Tuesday's lecture, today's lecture, and last Thursday's cases. So if y'all don't have any questions, I'll see y'all next Thursday because of Halloween and Election Day. All right, I'll see y'all in a week.